and thank you again for joining us for today's webinar, Australia's New Privacy Laws, What Small Businesses Need to Know. My name is Andrew McCallum. I'm the Manager of Membership and Community Engagement at Outer. It's great to welcome you to this webinar, which will explore some of the key areas businesses to be aware of and steps you can take to improve your business privacy and data compliance. Before we start, I would like to acknowledge and pay my respect to elders past and present, to those who've passed before us, and to the members of the Aboriginal and Torres Strait Islander community who are attending here today. I want to specifically acknowledge and pay my respects to the Wurundjeri people of the Kulin Nation, who are the traditional custodians of the land to which I'm coming to you. Before I introduce today's guest, I want to highlight that this webinar is scheduled for 45 minutes-ish and will be recorded. Now, turning to today, one of the really enjoyable aspects of my role at Outer is the opportunity to speak to small business owners from the small business community and the startup community across Australia. And when speaking about privacy laws, cybersecurity, website security, a common question is, do these really impact me? And the short answer is yes. With stricter consent rules, new marketing restrictions, a stronger focus on data protection, it's never been more crucial to understand your obligations. And the reality is that data privacy isn't just a legal requirement, it is a business necessity. Customers today expect transparency. They expect security when sharing their information, and failing to meet those expectations could mean reputational damage or even hefty penalties. And whether you're collecting customer details for marketing, storing client records, or handling transactions, understanding and implementing these new requirements will help future-proof your business. So without further delay, I'm delighted to introduce today's presenter, Alex Solo. Alex is the co-founder of Sprint Law, a law tech business with a mission to make legal services fast, simple, and affordable for small businesses everywhere. Since launching in 2017, Sprint Law have helped over 40,000 startups and small businesses, and we're the top-ranked legal business in the Financial Times APAC High Growth Companies list 2022, 23, and 24. No pressure for this year, Alex. Now 7 years old, Sprint Law have since launched operations in the UK and New Zealand. Sprint Law is one of Outer's affiliate partners and provided healthy discount on their services to .au members. Most importantly, Alex has been kind enough to share his extensive legal expertise with us today. Now, we will have time at the end of this presentation for questions, so please feel free to throw them in the Q&A section on the chat. We'll do our best to get to them and put them to Alex at the end of the presentation. So on that note, Alex, over to you. We're in your hands.
Thanks, Andrew, and hello, everyone. It's nice to be here and looking forward to talking about privacy law today. Before we get into the content of today's presentation, just to quickly introduce you all to Sprint Law. As Andrew mentioned, we're an online law firm. We specialize in helping startups and small businesses get on top of their legal stuff. We're quite different to traditional law firms that charge you by the hour. Everything we do is fixed fee. So, whether you need help with privacy and data stuff like we're talking about today, through to employment agreements, terms and conditions, getting your business set up, whatever else, we can give you a fixed fee quote and our lawyers can help you out. We also have a membership, which about 90% of our clients sign up to. It's got a great software where you can log in, make your own documents, e-signature tools. We've got a new legal AI tool, which you can use to ask questions and get instant answers, and a ton of other features as well. A bit more about us. As Andrew mentioned, we've been around since 2017. We've been growing very quickly. We have a big team of 50 staff, very down-to-earth lawyers, as you can see in that picture, and lots of positive reviews. And we're originally from Australia, but also have expanded to New Zealand and the UK as well. We have a special for Outer members. I think the Outer team will be dropping a link to this offer in the chat. As Andrew mentioned, there's a big discount that we're offering on our membership. So it's just $199 for the first year. You can sign up to the Sprint Law membership. It gives you access to unlimited quick calls with our lawyers, credits to spend on legal services, those free documents, the AI stuff I mentioned, e-signature tools. It's pretty good value, and it's all really meant to be designed to be at a super affordable price. So if you are gripped by the inexplicable urge to get some legal help after this presentation, do take advantage of the Outer offer. So into the content for today. We're going to be talking about privacy law. Now, the trigger for this presentation is, over the last year or two, there's been some pretty major changes to the way that privacy works in Australia. So we'll be going over some of the recent changes, many of which are coming into effect this year, and further changes that may be coming into effect next year that affect small businesses. So we'll talk about the changes, then we'll just go over the privacy essentials. What do you need to be doing, kind of starting from scratch, both in peacetime, just in the everyday of your business, as well as when something goes wrong, if your customers' information is breached. And finally, we'll talk about briefly some non-legal things you might also want to do to protect against privacy risks. As Andrew mentioned, as we're going through, we've got this Q&A feature in Zoom, so do feel free to drop questions in, and we'll have some time at the end to go through as many as we can. So let's kick off with what's happened, what's recently changed in privacy law. Well, in November 2024, late last year, the Privacy Act was amended with some pretty significant changes to privacy law. Now, the trigger for these amendments was the 2023 Privacy Act review, which was basically designed to address concerns that the Privacy Act 1988, a very outdated year you can see there, wasn't really suitable anymore for the digital age. In light of increased data breaches, evolving global standards, and increasingly fragmented laws that we had in Australia. And many people will recall the major data breaches that happened in 2022 affecting Medibank and Optus, which brought a lot of public attention to this issue around data protection and privacy law. And the GDPR, people may be aware of this, in Europe in 2018/19, some major changes were rolled out all across the UK and EU to the way they deal with privacy and data protection. And really trying to set a new global benchmark for how governments should regulate privacy in the digital age. Now, Australia is now, in 2023-24, looking at those laws and looking to follow suit a little bit. So all of these things happening, both domestically with the breaches as well as some changes internationally, have led to a lot of conversation in Australia, and hence finally some changes. So this review that was undertaken by the government recommended 116 amendments or reforms to that 1988 Privacy Act. There's so many reforms in there. Not all of them have sort of come into force yet. I mean, the government accepted of the 116, they accepted 38 of them, and they sort of completely, and then another 68 they've agreed in principle, but they want to do further consultation. And so what happened in November 2024 was that tranche 1, so a part of the changes that are coming, were passed in Parliament and have come into effect. The rest of them, the 68, have again been agreed in principle. The details need to be worked out and are likely to come in a tranche 2 bill that may be passed this year or early next year. So some changes have already come into effect and sort of more are coming. So what changed in November 2024? Well, I'll just go through each of the sort of major changes, particularly those that may affect smaller businesses. The first is we now in Australia have something called the Tort for Serious Invasions of Privacy. And so this is what we lawyers call a statutory cause of action. Basically, it means that individual people who have suffered an invasion of privacy are allowed to, under this law, commence legal proceedings. Previously, if you were a person and your privacy was invaded in some way, the best you could really do was complain to the regulator. You could try and make another legal claim if you wanted to sue a company or a person under, defamation law or some other kind of law, but there wasn't a specific way that you could say my privacy has been breached and therefore I'm going to sue you for breach of privacy. All you could do was complain. So this is pretty big change for individual rights. Now, some examples that might affect, for those of you running businesses that might affect your business, I got 3 on screen. One, we've got a marketing company. They've got customers' information. They're knowingly selling that to a third party without the consent of their customers. Now, previously, if that happened, maybe you could get fined by the regulator. Maybe the person could complain to the regulator. Now, the individual whose information has been sold actually can sue you potentially under this tort directly. So there's higher stakes for these breaches of privacy laws. A second is you're holding all your customers' information. You've got vulnerabilities that you know about but you haven't fixed. There is a data breach. Your customers' information is leaked. Someone impersonates them. They lose a ton of money. Again, that individual can potentially come after the business directly under this new tort, whereas before all they could do was really complain. And finally, surveillance. A small business has installed software on employees' work computers to monitor their keystrokes without telling them, and can see their personal communications without them being aware of it. Again, that employee could potentially make a claim against the organization. So these are some examples. Now, you can see the title of this cause of action is serious invasions of privacy. So it may not be successful if it's not what's considered serious, and there isn't a clear definition of what serious means. So it'll sort of be up to the first few cases and the courts to kind of work out what serious means. But it is significant. And again, a lot of what we see with small businesses, and this will be a theme as I sort of run through the slides, is we all may be sort of aware of the privacy laws, but a lot of small businesses are probably breaching them all the time without realizing it and have never suffered any consequences. What they're really trying to do with these new laws is raise the stakes of those breaches and increase enforcement. So the future may not resemble the past in terms of being able to sort of get away with the little privacy breaches, if that makes sense. So that's the tort for serious invasion of privacy. We've now got individual rights around this stuff. The next is doxing criminalization. So there's a new criminal offense for doxing. And for those that don't know what doxing is when somebody maliciously releases the personal data online of an individual. So, they'll post on social media or somewhere else someone's home address, home phone number, and name. That's called doxing. With the intent to sort of cause harm in some way to the individual whose data is released. This is now a criminal offense. Again, you can imagine all kinds of criminal scenarios, but an example for small businesses where you could be found to be doxing. A small business owner posts a LinkedIn update naming a disgruntled customer who left a negative review, and that review, maybe in the screenshot, has their name or their workplace or their email address. And maybe the business owner was sort of intending just to defend the business reputation and trying to show the reviewer as unreasonable. But if the customer does suffer harassment as a result, there is now a potential criminal penalty. So again, the stakes are higher now, and I've seen this online before with people posting on social media, email threads or screenshots when they've been sort of annoyed at a customer. How unreasonable is this customer, et cetera, et cetera. If it's got that personal information in there, it runs the risk of being doxing, and again, there's serious penalties for that. So this is again one of the new changes. Some more changes, automated decision making. We now have some laws around this stuff. So organizations who are using automated software to make decisions that affect individuals' rights now have to disclose what those decisions are and sort of how they're made. Now, a lot of the focus of this law is more on sort of governmental decisions, decisions to give people unemployment benefits and those sorts of things. And there's concerns that using artificial intelligence or software to make those decisions could lead to unjust outcomes. But the law is broad enough to also apply in a business context, certainly to banks and things like that are issuing home loans. If they are making the decision based on some algorithm, the individuals have to be sort of told what information is being used. It may use information like about credit scores or demographic details to make a decision, which could be discriminatory. And they may say, "Oh, that's just what the algorithm said," but the law's sort of putting some guardrails around this automated decision making. So, an example for a smaller business, and again, this is really in the lending space. It's difficult to think of too many examples of automated decision making outside of this context, but we've got a small online lending company who uses an algorithm to assess loan applications and approve or reject them. And the approvals are based on credit scores, income, spending patterns, and demographic details to make the decision. So if the lending company was trying to do that, it needs to let people know that's how it's making the decision. And of course, the individual may not want to share some of that information if they know it's going to be used against them, sort of thing. So yes, we have this law around automated decision making. Children's online privacy. The law requires a new privacy code to be developed for children to better protect minors' privacy online. So the OAIC is going to be releasing a privacy code. It's likely to not come out until next year. So there'll be a bit of a lag in terms of when we know the details of the significance of this legal change. But for those of you working with websites or software or services that involve children, it's worth being aware of this. Because you may need to make changes to the way your organization runs as this code comes in. So an example is an educational startup develops an online learning platform for primary school students. The platform collects personal information such as names, ages, and behavioral data to customize the content and track performance. So given that it's getting this information of the children, their names and their age, they've got to comply with the code. And so one of the things we expect to be in the code is, for example, you can't just require the child to click a button and say they've consented. You may actually need to take steps to ensure parental consent before you use children's personal information. Again, there's bits and pieces in the existing privacy law, but no clear section dealing with minors' privacy rights. So this is a pretty substantial change. And finally, and this is one of the big changes, is the enforcement and penalty power of the OAIC. And I sort of mentioned this earlier, but the OAIC has been sort of criticized for being what people have called a toothless tiger, in the sense that, in the past it's had a lot of potential penalties that it could issue to all kinds of organizations, but not many enforcement measures and not many resources to enforce the laws. And so some studies were showing that there's lots and lots of organizations breaching the laws with no consequence, and the OAIC hasn't really been able to do anything about it. So what we've seen with these laws is more proactive enforcement measures, more enforcement powers for the OAIC. They can issue compliant notices. They can issue pretty substantial penalties, up to $50 million penalties. Now they're unlikely to issue a $50 million penalty to a small business, but it can be a fairly substantial percentage of revenue that they can issue as penalties, and a much more of an ability to sort of not only go after larger organizations, but smaller ones as well. So, we've got an example here of an e-commerce business suffering a data breach, and exposing people's names, addresses, payment details, because their security is not up to date. So the OAIC could investigate the business, issue a compliance notice, sort of requiring them to fix their systems. And if they don't comply with that, they could get significant penalties. So, could be hundreds of thousands of dollars. And, if you're a small organization, fines of, $500,000 could be business ending for you. So, so they're really trying to make the penalties quite significant and give them these sort of proactive powers to get people to fix their systems as well. So again, as I said, the future may not resemble the past in terms of enforcement. And while you may not have heard of many organizations suffering from fines and penalties from the Privacy Commissioner, I would expect over the next few years it to become much more commonplace that we hear about enforcement happening from the OAIC. So those are the sort of key changes that came out in November 2024. Now, there's some pretty significant changes expected sort of this year or next year. This is part of those proposals that were accepted in principle, but a bit more consultations required. So up the top, and I'll go through this in more detail as I go through the Privacy Essentials, but it has been proposed and accepted that we're going to be removing the small business exemption to the Privacy Act. So for those that don't know what that is, if you're a small business with annual turnover of under 3 million, your compliance with many of the privacy laws is optional. Now, there's exceptions to that. If you, collect health information, or you trade in personal information, you're selling it, or you could collect sensitive types of information, you can't rely on this exemption. But for the majority of Australian small businesses, we have this sort of large loophole where there's all these privacy laws, but you actually don't have to comply. Many still do comply. Lawyers still will advise you to comply for many purposes. But there is this loophole, which is why you haven't seen that much small business enforcement of breaches of privacy laws. This thing is unique to Australia. It doesn't exist in other countries. Certainly under the GDPR, it applies to all organizations. And it's been proposed that this will be removed. Now, it's not law yet. There's still time for it to be challenged. But my view is it's likely to come into law this year or next year. So again, if you're a small business, I would encourage you not to rely on this exemption and just say, oh, well, technically it doesn't apply to me, because that's likely to be gone pretty soon. And you want to make sure you're sort of engaging in best practices now, so you don't have to make major changes when the law changes. Also, it's always been a good idea to comply. If your business goes over 3 million in turnover, if you expect it to ever do that, it's best to be compliant from day one to make sure you've got all the consents to keep working with your customers. Otherwise, there's a lot of things you have to do when you go over the 3 million mark. And there's various other reasons why you might want to comply with the privacy laws, building customer trust, et cetera, et cetera. So the small business exemption, a lot of people talk about it, but my view is it's never been the best thing to rely on. And certainly if it's abolished, we won't be able to rely on it anymore. So that's a pretty big change expected 2025, 2026. Some other changes, the right of erasure. This is something inspired by the GDPR. Individuals currently have pretty limited rights to contact an organization and say, hey, I want you to delete everything that you hold about me. It's been proposed that individuals should have that right, the right to contact any organization and say, what are you holding about me? And I request that you delete it. Now, we'll cover it a little bit later on, some rights people have now, but this will be a much stronger right. And again, put people more in control of their personal information. So a challenge for organizations will be working out how to comply with this, because if you reflect on your own organization right now, you've got people's names and emails in all kinds of places. You'll have it, in your inbox from their emails. Maybe you've got it in a spreadsheet somewhere. Maybe you've got it in your CRM system, in your business management systems. It could be all across your organization. And if someone says, delete everything that you hold about me, well, that's easier said than done, but you've got to be able to do it. So what we've seen in Europe in preparation for their, they call it the right to be forgotten there, a lot of organizations have had to sort of go into their systems and think about this question of where's people's name and email addresses and where do I store it, and centralize a lot of that storage so it's not in too many places, and get ready for complying with these requests. And certainly Sprint Law operates in the UK and we're compliant with the GDPR over there. It's pretty common practice there for us to get these requests, these erasure requests. And, obviously they're now sort of 7 years into having these updated privacy laws. It's become part of the culture there for individuals to have a stronger feel for their privacy rights. So again, I think that's where we're heading in Australia as well. So worth starting to shift your thinking around this stuff and look at how you can update your systems. Just to quickly go through some of the others, there may be modification to the employee records exemption. So currently employee names and records are exempt from the Privacy Act. You don't need to get complex consents and those sorts of things, but the reform's going to remove that exemption. There's some disclarity around the rights of controllers and processors under Australia privacy law. What we mean by that is, you as an organization, you may collect people's personal information, but you may then store it in third-party systems, Google or Microsoft systems, or as I said before, your CRM systems, your email systems, other tools that you may use. So those organizations are also holding your customers' information. They're what in Europe are called data processors, and you would be called the controller as the person controlling it. What rights do you have to check out your processes to make sure that they're complying with the privacy laws? there's some laws coming in around that. And again, it may be that all of a lot of businesses, including small businesses, are going to have to do a bit of checking of all of their suppliers and software tools to make sure they know what their privacy practices are. And again, I'd recommend that anyway, to do that now, but we may get some specific laws around that. More individual rights. We talked about the tort of serious invasion of privacy, so we're expecting more of that. And privacy impact assessments may become mandatory. And so again, right now, we of course would recommend people to conduct a full review of their systems and work out where people's personal information is, and work out what would happen if there was a breach. That's called a privacy impact assessment. They're recommended, but they may become compulsory for businesses to do, say, once a year. So some pretty significant changes that are expected and have been explicitly discussed. So you can see, certainly I've been a lawyer since 2014, 11 years, and there's been changes to the privacy laws. But this set of changes that came out last year and this year is by far the most significant changes to Australian privacy laws that I've seen since I became a lawyer. And I'm expecting it to be, there to be even more in the next couple of years. So if this is an area you haven't been thinking about in your organization, I would encourage you to really pay attention and start to get across some of these concepts, because I think it's going to creep up more and more into the way that you run your business. So those are all the changes, but let's go back to the beginning and talk about, in general, what should you be doing right now to make sure your organization is compliant with the privacy laws. So if we just start from the very beginning, I think for every organization, these are sort of three things that you should be thinking about. You should be thinking about, what am I doing to generally be compliant in what I referred to earlier as peacetime? In my day-to-day of the way I run my organization, what steps, what tools have I got in place to ensure that I'm complying with the laws? The minute we have notifiable data breaches, in wartime, if something goes wrong, if I'm subject to a ransomware attack, or if people's information is leaked, or I lose people's personal information, am I ready to go? Do I know what I need to do? And finally, for those of you who are directors of your organization, are you aware of your responsibilities in relation to privacy law, which are increasing, of course, in recent years? Because again, as a director, you can, in general, you're protected from having personal liability for issues in your organization. But if you breach your responsibilities as a director, you can be personally liable. And for those of us running businesses, we never want to be personally liable. That's why we've set up companies and things. So, of course, being aware of that as well is important. So I'll sort of go through, beginning with the general compliance. The first thing to understand is that in Australia, we have something called the Privacy Act. I've been talking about it on some of these first slides. It is the main piece of law in Australia that deals with privacy. And it talks a lot about the handling of personal information of individuals. And so this concept of personal information is really a key concept in privacy law. Personal information is any information about an individual that could be used to identify them, their name, their email address, their phone number, their address. Anytime you are handling that sort of stuff, someone else's name, someone's email address, someone's phone number, that's personal information, and the privacy law may apply. That's kind of the domain of what it deals with. So it's all about personal information. And anytime you're collecting it, using it, storing it, disclosing it in the private sector or public sector, this is where this law applies. So this is the sort of key law. And as I said earlier, this law currently it applies to personal information. It currently doesn't apply to businesses with turnover of 3 million or less, unless they are collecting health information or trading in personal information or handling some of these special categories of information, or fall under one of the exceptions. So if you're in that category, it may be that the Act today does not apply to you. As I said earlier, I wouldn't suggest relying on this exemption, because I think it might go in the next 12 months. And also, for the reasons I stated earlier, there's other reasons to comply. But the way the Act works today, there is this exemption for businesses with turnover of under 3 million. Now, I should say, some of the new laws for example, the tort for serious invasions of privacy and doxing, they don't have the small business exemption to these laws. So some of these laws are still going to apply to you. It's just a lot of the general compliance requirements are reduced for businesses with turnover of 3 million or less. So to comply with the Privacy Act, which I would advise everyone to do, there are a few things you need to do. First of all, you need to get some documents in place, and I'll go through what they are and how they work. You've got to prepare for wartime. You've got to have processes and procedures in place if there is a data breach. You've got to be able to deal with access requests. Right now, we don't have that right to erasure, but individuals can still ask you for information about personal information. You've got to be ready to comply with those. And there's some other non-legal tips that I'm going to go through as well to help you be compliant. So for better or worse, the Privacy Act unfortunately doesn't give you a list of documents that you need to put in place to comply with the Act. Instead, it has this sort of more conceptual approach where it says to comply with the Privacy Act, businesses must engage in the following principles: have the open and transparent management of personal information, be transparent about when they're collecting it, deal with it in certain ways, notify people at certain times, when transmitting it internationally, comply with certain standards. It has a very qualitative set of principles that organizations need to comply with. For the sort of average person reading the law, you'd read this and go, well, what do I actually need to do to be compliant with these laws? Fortunately, this Act's been around since 1988. There's been lots of cases, and lawyers have kind of worked out the documents that you need to really be ticking the boxes for the privacy laws. So we have on screen now the sort of principles in column 1, and then the kinds of documents that you may need to put in place. Now, there are some documents mentioned within those principles, but a lot of them don't have documents mentioned. But one of the documents that is mentioned, which we have right at the top, is a privacy policy. And APP1 says, anyone covered by the Privacy Act must have an up-to-date privacy policy about how it manages personal information. So for those of you who don't have one, or maybe downloaded a template online that might be American and not Australian, I would strongly advise you to get a privacy policy. It's the most basic requirement for complying with the Act. And in fact, about, you might argue, 50 to 60% of your compliance burden will be ticked just by having this policy in place, which is why everyone does them. So you need to get one of those. And the policy is going to set out how you're handling information, what you do with it, who you share it with, et cetera, et cetera. The second mandatory document, if you will, is called a privacy collection notice. This is, so it's all well and good to have a privacy policy stored in the footer of your website as a hyperlink, which in a small font, which a lot of people do. But if you don't provide links to that policy whenever you're collecting personal information, the policy is pretty much useless. So the law also requires that not only do you have the policy whenever you're actually collecting information, whether it's on a contact form on your website, maybe it's in person, you have a form people fill out, maybe it's a newsletter sign up, whatever it is. At the time of collection, you got to tell them that you're going to be using their personal information for XYZ purpose, and you got to provide a link to your privacy policy. So you'll see often on websites, people will say, by submitting this form, you agree to our privacy policy, and we'll be using this to contact you about our services. And it might say, tick here if you also want to join our newsletter. So that's what a collection notice is. It can be quite short, just a couple of sentences. But again, you have to actually actively link back to your policy whenever you're collecting that information. And that's a step a lot of people miss. A lot of people get the policy in place, chuck it online, and they say, oh, I'm compliant. But if they're not actually directing people to it whenever they collect information, then you're not actually ticking that key box for compliance. So those are the two big ones. You're probably at about 75% if you have both of them. Now, there's a bunch of optional documents which I would strongly recommend organizations consider. One is undergoing an impact assessment, kind of looking at the way your organization handles personal information and where all of the information is stored, and kind of recording that. If you do direct marketing, door sales, or outbound calling, there are some extra laws that apply to you. And so you should have a policy around that. That's pretty specific to direct marketing organizations, but worth being aware of if you engage in that. If you are sharing information with overseas contractors or suppliers, maybe you have an outsourced bookkeeping service, or maybe you have offshore contractors doing web development, you need to, you have a requirement under the APP8 to take reasonable steps to ensure that recipient does not breach Australian privacy law. In practice, what lawyers would advise you to do is in your contracts with any of those people, the bookkeepers, the web developers, whoever else, you have a paragraph in there that says you agree to comply. If you handle any of my customers' information, you agree to comply with the Australian privacy laws. And that way they are, even though they may not be based in Australia, you're bringing them under the scope of the Australian privacy laws. So that's also recommended for compliance with APP8. If you're found to sort of be sharing information with people overseas that are doing all kinds of things with it, and you didn't take any steps to get them to comply with the Australian privacy laws, you could be fined or penalised for breach of APP8. So it is worth getting that wording in there as a protection for you in case there's an issue with your supplier. Data breach response plan. This is prepping for wartime. If there is a data breach, are you ready to go? Do you know who you need to call, what you need to do, and who you need to tell? And we'll cover that in a bit more detail in a moment. And finally, access request and complaint handling guidelines. If someone asks you what information do you hold about me, do you have a process for replying to that, an email address they can contact, and steps to follow, which again, we'll go through it in a moment. So those are the key docs. Again, if just to reiterate, get a policy, get a collection notice if you don't have one already. Think about these, and if they apply to your business, if you're sending stuff overseas, maybe check those contracts and add an extra paragraph. If you're, again, we'll go through the breach and the access handling guidelines, but if you haven't thought about a data breach and what you might do about it, I would encourage you to do that as well. So beyond the Privacy Act, we have other laws other than that Privacy Act 1988 that also deal with privacy. And this is, part of what the new reforms are meant to address is that, there's kind of a patchwork of laws that businesses have to comply with. But it is worth being aware that your obligations may not end at the Privacy Act. If you're in a particular industry, if you deal with children's information, well, there's nothing in the Privacy Act. There is state-based law around, for example, in New South Wales, the Child and Young Persons Care and Protection Act. If you do email marketing, there's the Spam Act. You got to include unsubscribe links in your emails and get consent before emailing people. That's kind of privacy related. Outbound calling, there's a do not call register. If you're surveilling employees, you got to get their consent under the Workplace Surveillance Act. And if you're recording conversations, again, you got to tell people that you're doing it. So there are other laws, and this is a list of the kind of key ones. So again, if you're doing any of this stuff, worth being aware there may be some obligations and potentially getting some advice around that. So just to quickly talk about data breaches and what do we do if there is a data breach? So what happens if somebody hacks into your organization and steals your customers' information and threatens to release it on the dark web? That's an extreme data breach. Or a data breach may also be what happens if you accidentally forward an entire list of your customers to someone you shouldn't have sent it to, and it contains their name and personal information. These are both data breaches. Data breaches are situations where your customers' information has been shared with a third party in a way that they wouldn't expect it to have been or they didn't approve of. If that occurs, you have obligations as the person that was holding it. So under the notifiable data breach scheme, which came out in 2019, I think it was in Australia, there are specific steps that you need to take. First of all, you got to do your best to contain the breach. If it's a ransomware attack, you've got to get onto some cybersecurity experts and get them to get the hackers out of your system and close the hole. If it's a email that's been forwarded, you might put a recall on the email, or make sure that more emails like that won't be sent out. But you got to take active steps straight away to contain it. Once you've taken steps to contain it, you got to assess the damage and try and work out who's affected. The ideal thing is to get a list of customers as quickly as possible that have been affected, if you can, so you know whose information has been breached. Then thirdly, you have to decide whether you need to notify them. Now, the law is a little flexible here. You don't always have to notify people if a data breach occurs, But if there is a substantial risk of harm to them, you have to not only notify them, you also have to notify the OAIC and tell the regulator, hey, we've suffered a data breach. So in the example I gave where a ransomware attack's occurred and someone's threatening to release it on the dark web, that's a pretty significant risk of harm to the individuals affected. So you're going to have to notify the regulator and likely notify them. We're really sorry this has occurred. Someone exploited a problem in our system and your information's been breached. Now, if one email of someone has accidentally been forwarded to the wrong person and it's got their name and email address in it on the other extreme, that's technically a data breach, but it doesn't pass the test of, potentially doesn't pass the test of substantial risk of harm to the individual. So you may not have to tell them. So that's an assessment you have to make, ideally with the help of lawyers. And if you get it wrong, you can get in pretty serious trouble. So you want to be conservative around how you think about that. But again, if it's just an accidental email forward, which does happen all the time, the law's not expecting you to sound the alarms. But if something significant happens, you've got to be sort of ready to go. And then finally, afterwards, you've got to review your process. Now, this process is required by law. And if you comply with this process really well and you have a procedure in place prior to it happening to comply with it, your likelihood of being fined, penalized, or sued goes down significantly. If you don't do any of this stuff and it just happens and you throw your arms up in the air and you get stressed out, but you don't actually take any steps to contain it, you don't tell anyone about it, you can, even though it's not your fault that you were ransomware attacked, you can be found liable and you can be fined and you can be penalized. So it is really important to kind of be ready for the data breach before it happens, and sort of know what you need to do. So hopefully that makes a little bit of sense around data breaches. And finally, just dealing with the access requests I mentioned earlier. People should have a process in place now. There's these laws around giving people access to information about how you hold the personal information. All organizations should have a dedicated email address or person in the organization who is their privacy contact. And for example, for Sprint Law on our website, inside our privacy policy, we have an email address, privacy@sprintlaw.com.au. People can contact at any time. And again, that's great for compliance. Someone can email that, say, what's Sprint Law holding about me? I want to know, and they may ask you to remove it, which you may or may not have to do. There isn't this right to erasure yet, so you can refuse it. But again, you have to at least take steps to reply to these requests. So for those of you that don't have that set up, I'd suggest setting up an email address. It can even just be your general email address, and publish it on your website explicitly saying, if you've got a question about privacy, you can contact us here. And then being ready to comply. If someone emails you, again, you want to know where the information is, so you could send them an email saying, this is the sort of information we hold about you and this is what we use it for. And again, I expect the law around this to become a little more substantial in the next 12 months. But yes, I mentioned right now, you are allowed to refuse their request if it's difficult for you to comply. If they ask you to delete everything you hold about them and that's hard to do, or give you a itemized history of every time they've communicated with you, there are circumstances we can say, well, that's too hard right now. So it's not a very onerous requirement right now, but as I said, that may change. So finally, we've covered a lot of legal stuff. I would, of course, advise people to do more than just get a privacy policy and a cookie policy in place and think about some of these data breach risks. Consider cyber insurance. If something does go wrong, your insurers can really help out in terms of protecting you from losses and helping you find the right experts. Get IT professionals to help you review your systems to prevent the likelihood of breaches. Look across your organization for where people's personal information is held. Make sure it's not being leaked in all kinds of spreadsheets and places, but it's all kept in one spot. Train your staff, train your team on how to prevent risks of data breaches, and build some of these internal policies, because if a breach occurs, there's these legal steps that you can take, but also it'd be much better if it never occurred at all. And a lot of that is more about technical assistance than legal assistance. So that's the end of the content. Hopefully we have a little bit of time for some questions, but just a reminder for all of you that we have this offer for all Outer members, which I think the link is in the chat now if people want to sort of access the offer. So do feel free to claim it if you want some legal advice. And I might just hand back over to Andrew. I think wants to cover a couple of things.
Thank you, Alex, and that's I fully appreciate that's an incredibly complex topic that you've managed to digest into 45 minutes. So thank you for that. I do have just a couple of questions which we will rush through. And one relates to right of erasure, which I know you spoke about late there, but let's give you a scenario. A user requests what information is held. Deleting the data is obviously relatively straightforward, but where does it end? Does it extend to email communication between the client and the business? Does it extend to phone call data records, those sorts of things? Is it everything?
Yeah, the answer is it is technically everything, including email threads. Now, email threads is one of the most difficult things to delete because there could be a lot of emails, and you may not have a structured way of storing the emails. I should clarify the right to erasure doesn't yet exist in Australia. It exists under the GDPR as a right to be forgotten, and so we don't know exactly how the law is going to pan out in Australia. But the way it works under the GDPR, which will be the model for how it works in Australia, is yes, that emails have to go. Now, a lot of people find ways to refuse to delete emails. There's an exception under the right to be forgotten that, if there's a legal purpose for holding them or a legal obligation under which you need to hold them, or some other law requires you to have them, or there's a good reason, you can make that counter argument. And certainly, for example, for us as lawyers, we're required to keep all client solicitor communications for 7 years. So even though if someone might ask us to erase their information, we can erase them from a lot of our systems and marketing systems, but we would have to say to them, well, actually this legal profession law trumps out. We've got to keep your emails. So there's creative ways to refuse the email request, and it depends on what you do. But as a general position, yes, they would have to go, at least under the GDPR, unclear about Australia.
Okay, thank you. And another question, which I think you're well qualified to answer. Can you estimate when the Tranche 2 privacy amendments will be coming in? When do you expect them to take effect?
It's an interesting question. Yeah. People thought they would come into effect this year. It is an election year, so it's possible that they don't want to make big changes this year, or it's expected to be anyway. So I think I think it's more likely to be early 2026. I'm closely following it because it's going to be a major change for Sprint Law, of course, and particularly as that small business exemption gets abolished. But yeah, I would be surprised if it takes more than 18 months from today. So definitely within the next 18 months is my prediction.
The scary thing is early 2026 is less than 18 months.
Yes, that is scary.
And can I just ask too, these changes are significant and do impact a lot of businesses, but what are some of the very real misconceptions that you guys come across when talking to them with your clients?
I think a lot of people don't. Okay, so one is a lot of people think all they need is a privacy policy, and they also think they can just copy and paste it from some other website. And the problem with that is, as I highlighted earlier, it's not just about the policy. You've got to distribute it every time you're collecting people's personal information. And so you're really not doing much with the policy if it just sits there on your website. And second of all, when you copy and paste, there's so many different privacy regimes all around the world. There's the CCPA in California, the GDPR in the UK. Australia has quite a specific Privacy Act, and even some medium or large organizations, you might think you're safe because you copied the privacy policy of a big Australian organization. Sadly, a lot of them are non-compliant, and I've seen more and more fines get issued by them. So, a lot of our clients, we do a legal health check, and they say, I've already got my privacy policy. And we actually have some of our team go to their websites and check, and the percentage of them that have an incorrect policy, it's either outdated or from another country, is surprisingly high. It's 30 or 40% of people that copy seem to get it wrong. So that I'd say is probably the biggest one, yeah.
Okay. All right. Look, and thank you to those people who've had those questions. We have reached the end of our session today, so we do need to wrap up there. Again, thank you for taking the time to attend, and a big thank you, obviously, to you, Alex, for putting that content together and for what's a very interesting presentation on a very, very important topic. I do just want to very quickly mention a couple of events coming up. We will be in Tasmania and Canberra over the coming weeks, so if you find yourself in either of those places, we'd love you to join us. Details for all upcoming in-person and online events can always be found on the events page of the Outer website. A reminder also that if you miss a webinar such as this one, you can always access those on demand via the .au member portal, which is free for all members. And as always, if you're not already a .au member, I strongly encourage you to join. .au membership is complimentary and connects you to a range of resources and events. You can join again via the Outer website. An important reminder, of course, that is part of the member benefits is the discounted membership offer with Sprint Law. So to quote Alex, if you are gripped by the need to source legal advice, then those guys are there to help.